The Securities and Exchange Commission, SEC, asked Ripple to submit financial records to the court. A judge made the ruling in July that institutional investors are the only ones who can buy XRP as a security. This verdict was rendered in accordance with the order. The Securities and Exchange Commission's attorneys had asked the federal court for a decision of this kind, and the Commission's findings had validated their request. The Securities and Exchange Commission requested on January 11 that Judge Sarah Netburn give Ripple access to the business's 2022 to 2023 financial data. In the United States District Court for the Southern District of New York, the Securities and Exchange Commission, SEC, issued a request to Ripple to disclose post-complaint institutional sales contracts. Only institutional investors are permitted to purchase XRP as a result of a July 2023 court judgment. The Commission was able to draw a link between institutional sales contracts and this decision. The Securities and Exchange Commission sued Ripple in 2020, alleging that the business had tried to profit from the sale of securities that weren't registered. The SEC requested financing. Restricted and focused discovery was sought by the Securities and Exchange Commission, SEC, after Ripple violated Section 5 of the Securities Act of 1933. Judge Torres had all the facts he needed to decide between injunctions and civil fines. It also sparked questions about the severity of civil penalties. The CEO, Brad Garlinghouse, and Executive Chair, Chris Larsen, were listed as defendants in the indictment. Despite the fact that the charges made by Garlinghouse and Larsen were placed on hold in October 2023, the Commission intends to take the Bitcoin Corporation to court. During the legal dispute between the two XRP coins, Stuart Alder, the chief court officer of Ripple, described the Securities and Exchange Commission as an excessively controlling regulatory body. This happened all the way through the currency war. Ripple started experimenting with SEC in April. The Commission's conclusions state that Binance and Coinbase complied with sanctions throughout the investigation. Some owners of XRP are worried about the scenario's overwhelming presence. A reputable legal expert's interpretation of the relevant cum forms the basis of this dispute. The fact that Ripple and the SEC have not made their ongoing legal conflict public has led to something similar happening. The United States District Court for the Southern District of New York has not acted since November 2000, when the Remedies phase scheduling order was granted. This is a result of the ongoing legal battle. This situation still exists now, as it did then. Supporters of XRP have turned to a variety of social media channels to express their unhappiness. He was surprised that the SEC had not filed a discovery motion for damages, even though the complaint was written in an enraged tone. He was astounded by what he had discovered. It was surprising to him to learn this. He is worried because the Securities and Exchange Commission will submit this motion at least 77 days before February 12, 2024. This is something that worries him. After giving every option considerable thought, the lawyer decided that the Securities and Exchange Commission, SEC, would receive the discovery material right away, which led to a collection of people. Because the secretary did not answer the first question when it was posed, the lawyer throughout the ensuing legal dispute made further assumptions. To accelerate the process of giving investors who have forgotten about their investments relief, he suggests that the Securities and Exchange Commission, SEC, file a motion to overturn the Second Circuit Court of Appeals summary judgment ruling. As such, this would expedite the process. The Securities and Exchange Commission, SEC, filed an interlocutory appeal as soon as the summary verdict was rendered. With its appeal, the SEC was able to have some degree of success. The regulator was ordered by the court to postpone its appeal until all outstanding concerns were resolved, even though the motion was denied. The SEC can file an appeal of the decision more quickly than it might have if it hadn't chosen to sue Ripple employees the year before. We considered this choice while rendering our decision. Since the cure briefing is the only item that hasn't changed, the goal of this is to make the audience feel as though they are touching anything. After the remedial briefing on April 29, 2024, early in the summer of 2024, a decision is expected. William Morgan, a well-known Australian lawyer, is happy with the decision made on XRP's security status. Morgan's tweet from yesterday seems to indicate that the ongoing discussion about XRP's non-security categorization has come to a conclusion with the SEC's most recent move in the Ripple case. XRP's attorney also made a very similar comment. December 2020 saw the resolution of the dispute over XRP security. We have recently launched a campaign to sell limitless downloads without any limits, even though a complaint has been filed. It is quite likely that this dispute will go on for a long time because Ripple has objected to every document and question contained in the initial request. Since Ripple turned down every single one of them, the Securities and Exchange Commission (SEC) made a fresh attempt yesterday to force Ripple to provide two crucial papers and reply to a formal inquiry. The move was intended to achieve compulsion. The motion specifically asked Ripple to comply. The bundles include two documents: the post-complaint contract that governs the sales of XRP to institutions and the company's audited financial statements for the years 2022 and 2023. The paper bundles contain both of the documents. Attorney Morgan was shown a section of the latest document the SEC had produced that described the organization's attempt to file an interlocutory appeal early in the proceedings. The SEC's most recent request has an unexpected twist. Since the petition was filed, the SEC has supplied this information. The Securities and Exchange Commission's attorney said they needed permission to start an interlocutory appeal in order to challenge the court's ruling that certain Ripple's XRP offers and sales were not securities. The judge found that Ripple's programmatic sales and other XRP releases complied with requirements. She concluded that XRP is not a security in and of itself, despite the fact that many people thought the Securities and Exchange Commission would be unhappy with the legal status of XRP rather than that it simply attempted to contest the summary judgment regarding Ripple's programmatic sales of XRP and other securities. Nevertheless, the SEC's application to file an interlocutory appeal omitted any mention of the issue. It is probable that the Securities and Exchange Commission, SEC, will continue to defend the finding about Ripple's programmed sales and other XRP distributions if it files an appeal following the remedies phase of the Ripple litigation. That's not impossible. In the event that the agency files an appeal, this takes place. After addressing their differences over XRP's non-security status, the parties have begun fighting for post-complaint ODL sales, according to an attorney by the name of Morgan. This fight is expected to start in December 2020. He conjectured that the XRP community will have to fight a bloody legal battle throughout the remedies phase because Ripple has objected to every single one of the SEC's requests for documents and interrogation statements. Repurchasing its own shares is a regular practice for Ripple in order to keep its promise of liquidity. Customers are quite happy that the company changed its plans for the initial public offering, thus, that's why this decision was made. The CEO of Ripple, Brad Garlinghouse, said that the company will not be going public in the US. This comment was offered to provide additional clarity regarding this strategic choice. He was being cautious because he was worried about following the law and regulations. Anyhow, that was all that mattered at the moment.